Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
Hello, Dr. Suzanne Bechtel is here to give you a lecture on remedies for seller and buyer under UCC Article 2. We're going to talk about seller and buyer remedies and what the seller or buyer can have done as a remedy with respect to a contractual promise. Our focus here will be on Part 7 on seller and buyer remedies in breach or non-performance, that being Part 7, Article 2. And as I pointed out, this is Part 7. This is on Part 7 of the UCC. Article 2 focuses on the remedies available to the seller or to the buyer in the event of a breach by the other party or for non-performance. All right, seller remedies. We're going to look at withholding delivery and COD bases for insolvent buyers, suing for damages, contract cancellation, and reclaiming goods. All right, so this is in Part 7 of the UCC, where Article 2 focuses on the remedies available to the seller or the buyer in the event of a breach by the other party for non-performance. So with the seller remedies available, if the buyer is in breach and the seller is the innocent party, what can they do? Well, first of all, they can withhold delivery of goods. They can not deliver the goods that the buyer is refusing to pay for. And then something else with respect to breach, if the buyer is insolvent, they can put them on a COD basis, cash on delivery is what that means, which means the goods will not be delivered and left there unless they pay cash at the same time. If the goods are in transit already, they can stop those. If they're in the possession of a third-party carrier, like on a ship or train or truck or something like that, they can make arrangements with that third-party carrier to stop the goods where they are. I suppose if they're on a boat carrier, they just stop and dump them in the sea. I'm sorry, I couldn't help it. All right, moving on. They could also, I guess they could. They could break some other laws, but there you go. They could also resell the goods in some commercially reasonable manner. So reselling them to another buyer or anything else that they can work out to get paid for those goods so that they can recover from it, the seller can recover from it, since they're unwilling to sell them to the buyer. Now, those are things to try if it becomes clear that breach is happening. If the breach has already happened, they can certainly sue for damages. You would calculate those damages based on contract price minus the market price at the time of breach, plus any incidental damages. And they can cancel the contract and proceed to sue as well. They could go back and reclaim the goods delivered to the insolvent buyer if they'd already been delivered, following a timely demand for payment or return of the goods. So those are some options that they have available. All right, so buyer's remedies for breach. So this is where the buyer is. So we're going to go into suing for damages and calculation of actual damages, equitable remedies, and specific performance and replevin. Now, if we're talking about the buyer, and the seller is the one that's in breach. And that's, the things the buyers can do. They can sue for damages, which is a typical remedy. They can request the actual damages, which are excessive market price over the contract price at the time of breach in the place of delivery. So it's time bound, and that's important to understand. Along with your obligation to mitigate damages, for any party to breach of contract, you can purchase substitute goods to mitigate damages and then sue for the difference in price. So if you have to buy the goods that the seller is not delivering as contractually promised, and you have to pay more for those, then you can sue for the increased price that you had to pay. And it would be common to do this in trying to get something at the last minute. The price would be increased. Just timing is everything. Other remedies are specific, and they're called specifically equitable remedies, and these are where no legal remedy is appropriate. Remember, legal remedies are money, so we're telling you about money damages. And sometimes money damages are not going to fix the breach or properly compensate the buyer. So what you're going to look at with equitable remedies is other remedies. And the first one is something unique to contract law, and that's called specific performance. So if the goods were unique, meaning it's not something you could obtain elsewhere, and there was no way to cover the costs of that, as a buyer, you could sue for specific performance and ask the court to order the seller to deliver those specific items or goods. So, for example, a one-of-a-kind painting or other items that cannot be easily replaced, that would fall under that category. And replevin is where you're asking the court to order the seller to turn over the goods in accordance with the contract. Other buyer remedies, reselling the goods after rejection and contract cancellation. Buyers can also resell the goods after notifying the seller. They're rejecting them due to nonconformity. What that means is if the seller delivers goods that do not conform to the terms of the contract, that the buyer has to notify the seller. And they need to let them know that they're rejecting the goods. And if the seller doesn't take them back and provide proper replacements, they can actually, the buyer can actually resell those goods to try and recuperate some of their losses. The buyer can cancel the contract and sue for damages as well. And they can revoke their acceptance of the contract, and that'll depend on the contract language. And they could agree to keep them and just move on. The non-conforming goods, meaning goods that don't conform with the terms of the contract, they can keep them with an adjustment in price. So paying a lesser amount because the goods are non-conforming is basically what we're talking about. So there there are lots of different remedies that buyers and sellers can try. And obviously going to court is the last option because the time and expense of that. So some of these here can work out on their own without going to court. All right, looking at contractual remedies and limitations, we're going to look at liquidated damages and reasonableness of those damages, consumer goods and unconscionability in limiting damages for personal for the area. So other contractual remedies or things to keep in mind are liquidated damages. Liquidated damages must be reasonable in light of the circumstances. And liquidated damages are where the language in the contract sets what the damages would be in case of breach. So it actually anticipates if there's a breach of this contract. And here's, if that happens, here's what the damages are, what they'll look like. It's already set up and it's set out in advance. It's almost akin to a prenuptial agreement for a couple getting married where they're saying things don't work out and we get divorced. Here's what the alimony is going to be, here's what the property distribution is going to be, etc., etc. And the same type of thing in a contract with a liquidated damages clause. And consequential damages may be limited or excluded in that clause. And consequential damages are losses to one party based on the breach of contract that aren't the actual loss of the goods or the money for the goods, but damages that occurred due to the lack of those goods. For example, if you're ordering widgets is a business term for things that it's just a nomenclature. In business classes, we use widgets in law classes. Anyway, if you're ordering widgets and you need those widgets to complete a larger project, and because they don't come in, it's not just the loss of value of the widgets it's that you're going to pay for, but the larger project is affected. And they were going to use the widgets for the larger project, and that can be built in. And then there's losses involved with that as well. Anticipatory repudiation under the UCC is an opportunity to perform a material change of position. We're going to talk about that, the intent to repudiate and options for non-repudiating party, retraction of repudiation and its effects, and demand for adequate assurances and consequences of failure. So the term anticipatory repudiation, and this is in the UCC, it really will give each party an opportunity to perform their contractual obligations unless there's some material change of position by the non-breaching party. So I'm not going to get into a lot of detail on this. We just want you to be generally familiar with it. And the parties in this case would have to indicate they intend to repudiate before time of performance, and the non-repudiating party has some options to either sit and wait for the performance, try to remedy the performance or suspend it, and try to salvage or identify the goods involved. And there's more and more on this topic, but I'm going to pass this a little bit. Now we're going to look at the doctrine of impracticability, where there's an excuse for non-performance due to impracticability, and we're going to look at the procedure for it. The doctrine of impracticability under the UCC is an anticipatory type of situation that there may be circumstances that are beyond the control of the buyer and the seller that make performance of duties under the contract impracticable due to outside circumstances. And whether that would be something like a severe weather event or war, or, we had the pandemic. That was a more recent example that could be the possibility. So if you give notice that it's become impracticable, it's possible to terminate the contract. And we did see this a lot with COVID and different things where it just became impracticable to virtually impossible to perform as agreed under contracts. The procedure for this is under UCC 2-2615, and that's where you'll find the legal grounds listed. A seasonable notice requirement. A party must give timely notice to be excused from the contract under this provision of impracticability, and upon proper notice, the contract may be terminated legally due to impracticability. And I think this is last of besides the practical applications, which is normally last, but this one, it covers statute of limitations and practical applications. So the statute of limitations is 4 years under the UCC for suing for breach of contract. If you wait longer than 4 years, you can't bring a lawsuit because the time has expired. Now, a contract may provide a different term, so you would look at that from the contract as well. And parties, however, cannot agree to a statute of limitations period that is shorter than 1 year, but they could agree to something like 3 years or 10 years, or they could agree to longer than 4 years, which is what is provided in the UCC. So when you're drafting remedy provisions to avoid penalties or unconscionability, ensure the remedy provisions do not impose excessive or punitive penalties that courts may reject. To prevent unconscionability, you can draft terms that are fair and balanced and this helps prevent being deemed unconscionable or oppressive. And be sure to draft along with it clear, reasonable remedies to ensure enforceability and avoid disputes. And that's what you need to do. So you don't want to create something that's not going to be upheld. Should it be challenged in court?
I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.